10 seconds to go. In respect of other issues relating to execution of extra work, the trial court based its findings on the materials placed, accepted certain items in toto, and rejected certain claims, and ultimately rightly granted a decree for a sum of rupees 2 lakhs with proportionate costs and interest of 6% per annum from the date of the suit till realization, and the plaintiff is entitled to the said amount. The impugned judgment of the High Court is set aside, and the judgment and decree of the trial court restored. The issue that falls for consideration in the present appeals is whether the appellant would be entitled for refund of the tax which was paid by him to the seller in view of the provisions of Section 44 of the Kerala General Sales Tax Act 1963. One additional issue which was urged at the time of hearing of the appeals and requires consideration by this court is as to whether the appellant at all be entitled to claim exemption under Section 5(3) of the Central Tax Act 1956, as at the time of sales the appellant could not allegedly show any evidence that it was the penultimate sale of tea. The appellants are exporters of tea. The appellant, being the exporter of the aforesaid consignment, claimed for exemption on the ground that the purchase was exempted under Section 5(3) of the CST Act. The said claim for exemption was also found to be genuine by the assessing authority and was allowed in full. The appellant also made a claim for refund of tax collected from them by the seller at the time of purchase of tea. The said claim was rejected by the assessing authority, and it was held that they cannot claim for refund under Section 44 of the KGST Act, since they have not paid tax to the department, but it was the sellers who have paid the tax, and therefore under the provisions of Section 44 of the KGST Act, the refund that could be made is to the dealer only, and the assessee being not a dealer, no such refund could be made to the appellant or assessee. Being aggrieved by the aforesaid order, the appellant filed an appeal before the Deputy Commissioner Appeals, who considered the contentions of the appellant, and upon going through the records found that there is an observation recorded by the assessing authority that the export sales is pursuant to the prior contract or prior order of the foreign buyers, and also that export sales are supported by bill of lading, export invoices, etc. The appellant, a private limited company, had auctioned a number of paintings on 28th November 2002. Two paintings were purchased by Tony Hans of England. The said two paintings were to be exported. The customs authorities had detained these paintings on the suspicion that the said paintings were antiques within the meaning of the provisions of Antiquities and Art Treasures Act 1972, herein after referred to, as the Act